Justices of the Supreme Court made their way to the fully packed chambers at 19 minutes past 10 a.m. this morning for the pre-hearing conference. While appearing before court, Amama Mbabazi's lawyers, led by Amama Mbabazi, asked court if they could be availed hard copies of the tally sheets and declaration of results forms from all the districts. The lead counsel revealed that they had only been served with the final forms signed by the Electoral Commission chairperson.
The tally sheets we are looking for are the ones signed by the district returning officers, because the engineer Bantu Kigondo was not in all the districts. I think this one, the commission knows when you go to section 54 and 56.
The lead counsel of the Electoral Commission, which is the second respondent, Enos Tumsime, told court that this would require time to avail the tally sheets and declaration of results forms. However, the Chief Justice Bat Katrebe invoked the Presidential Elections Act, which requires the Electoral Commission to comply with this provision in 7 days.
However, if they're interested in looking at the hard copies, they will also be availed at the time.
Upon completing the return under subsection 1, the returning officer shall transmit to the Commission the following documents. A, the return form. B was repeated. Then C, the tally sheets. And D, the declaration of results forms from which the official addition of the votes was made. So these documents were supposed to have been transmitted to the second respondent. So at least they should be there. I don't know whether these are the documents that Mr. Mbabazi is looking for.
Much obliged.
But this is now a matter of what the law requires to have been done.
The EC was given 2 days to avail the hard copies of these forms. Earlier on in the day, lawyers of the petitioner Amama Mbabazi, the first respondent Yoweri Museveni, the second respondent the Electoral Commission, and the third respondent the Attorney General were able to frame issues for the highest appellate court to determine. The issues include whether there was non-compliance with the provisions of the Presidential Elections Act and the Electoral Commissions Act in conduct of the 2016 general elections, whether the said election was not conducted in compliance with the principles laid in the provisions of the Presidential Elections Act and the Electoral Commissions Act. If issue 1 or 2 are answered in the affirmative, whether such a non-compliance affected the result of the presidential election in a substantial manner, whether an offense under the Presidential Elections Act was committed in connection with the election by the first respondent, who is the President personally, owing to his knowledge and consent or approval, whether the third respondent is properly joined as party to this petition, and whether the petitioner is entitled to any relief sought. However, these were some of the issues framed by the petitioners, which were contested by the Deputy Attorney General. Whether the second respondent relied on any results from the polling stations and district tally centers as a basis to declare the first respondent the winner of the 2016 presidential election, whether the petition is entitled to a preliminary relief of vote recount in the area specified in the petition, and whether there was a national register compiled, maintained and updated by the second respondent for the 2016 presidential election. The lawyers, however, agreed to these facts that there was a presidential election conducted by the second respondent on the 18th of February 2016, and on the 20th of February, the first respondent was declared the validly elected president with 5,617,503 votes, representing 60.75% of the valid votes cast. They also agreed on the fact that on the 20th of February 2016, the petitioner was declared to have polled 132,574 votes, representing 1.43% of the valid votes cast.
Court is of the view that the agreed issues will enable court to inquire appropriately into the petition. Accordingly, court endorses the agreed issues as agreed by both sides.
The main hearing of the case will start on Monday, where the petitioner has been given 2 days to present his evidence and 1 day for each of the 3 respondents to file their defense. On the 12th of this month, which is Saturday, the Supreme Court justices will be coming back here at the Supreme Court, whereby they will be hearing the applications that have been filed by the Makerere University law dons and members of the civil society, where they want to be an external party and friends of court. Suhail Mugavi, NTV, at the Supreme Court, Kampala.